uh, got to take care of that part first. Okay. So who's up?
You.
I'm up. Okay. Well.
Oh no, I'm up now. Okay. So the definition of estate planning is that I want to control my property while I am alive and take care of myself and my loved ones if I become disabled or incapacitated, and give what I have to whom I want, the way I want, when I want, if I can. I want to save every last tax dollar, professional fee, and court cost possible.
Yeah.
So basically, the definition of estate planning is you dictate what happens to your assets while you are alive and not well as after you pass away.
Excellent point. Yes.
Okay, so estate planning, obviously we're estate planning attorneys. That is what we live and breathe and talk about all day. But Roxanne, what is the goal of all of this? What is the goal of estate planning?
That's a really good question. Goals vary from person to person. So for a family such as mine, it could be our goal in estate planning to protect my spouse or my minor children. In the event something happens and I become incapacitated, or if I pass away, we want to protect my immediate family members.
Yeah.
Another goal could be protecting my spouse from future predators. I say this in jest, but it's kind of true that if I were to die before my husband, it's probably likely that he will remarry, not because we have an unhappy marriage, but more that we are strong believers that having a partner in life just makes life easier. And so if I predecease him, I think he's going to remarry, and I trust him, but who do I not trust? Maybe his future wife.
Maybe that's
the new wife. Cruise ship Irene. So in that situation, we may want to plan for one of us passing away and protecting our spouse from future predators, that future spouse.
Roxanne, when I think of this, I think of before we get to there, but I do think of people that are getting along to my age and beyond. Where we become susceptible to undue influence from perhaps caretakers or people that enter our lives. And so protection around that, it can also be important. I think a lot of spouses do worry about that, about the incapacity of the surviving spouse and having that person taken advantage of. Yeah. Okay.
Absolutely. And I'm glad you brought that up, Bob, because, protecting our elder population from those influences, and because they're a vulnerable part of our population, it's really, really important. So that is a really good point. Thank you. Another one of our goals could be protecting our older children from bad choices. And, maybe I have a fear that my own child, when they grow up and they're adults, are making poor decisions. Maybe they marry somebody who doesn't have the best financial sense. Or maybe my child develops habits that are dangerous to themselves and those around them. It could be an addiction or a love for shopping when they don't have any money. It could be a number of things. So you can put in place provisions to protect the children from their own bad choices. And that could be a very good goal of a family's estate planning matter.
Yeah. And substance abuse and, gambling addiction is just unfortunately, it's quite pervasive in our society now, and protecting people from that can be we use trust to protect people, and sometimes we use them to protect people from themselves, I guess. Huh? Yeah.
Mm-hmm. Exactly. And I think gambling addictions are increasing compared to, what you would typically think of as like a regular or a common addiction. Like the gambling addiction is common now too. Another goal could be balancing beneficiaries in a blended family. So say, for example, if my husband and I had brought different children to our joint marriage, and if one of us passes away, we want to make sure that each of our sets of children are protected, even though it's a blended family. So in that instance, that could be a very common goal for our families and our clients.
Good point.
Okay. And last but not least, one of our goals in estate planning could be leaving a social legacy. If we have charitable intent, we may want to set up some sort of contribution to a charity or an organization that means a lot to us. Maybe we want to set up something that pays out over a period of time. Maybe we want something that distributes to the charity at our deaths. It could be any number of things. So if there is a client that comes in with charitable intent, that achieving that charitable intent or carrying it through could very well be a goal of our clients. Okay. So as you can see, goals are different for everybody. Go ahead, Bob.
No, it makes good sense. And then I think we're going to get to caring for the family here.
There we go. So
yeah. So here we're talking about, again, a goal of estate planning is certainly protecting one's dignity, providing for the appropriate care, the appropriate people stepping in to help out in the event of, we have disability here, but we're really talking about incapacity. You know, as we age and we become maybe need help with taking care of paying the bills, whatever it may be, allowing that to be an informal process outside of the courts, in families that are that work together, having people step in. If they don't work together, having private professional fiduciaries or corporate fiduciaries step in to handle these things and do so that the individual isn't exposed to court hearings and that type of thing. It can be very effective. Yes. So that providing those instructions and care for family, you know, this would be, there's two ends to this. Number one is leaving instructions for the care of our young ones. So Roxanne, you have two little boys, and so you might have instructions for your guardian and trustee who might step in if something happened to you and your husband. On the other end, somebody, an individual who, particularly an individual without, maybe doesn't have close family, might be a surviving spouse that without close children or close ties with family, will want to provide instructions in the event of incapacity, so that there's an understanding as to what that individual would want if there was incapacity, you know, what kind of care they would want and where they would like to, if they'd like to stay at home, whether moving into a residential care facility would be something that they would be appropriate. All that can be done within a trust. Yeah, within an estate plan.
well, what about those instances where a family doesn't have an estate plan?
Well, I guess.
Or are we going to what is an estate?
Yeah. Well,
Oh, it is an estate.
well, yeah.
So what is an estate? An estate is comprised of many different things, but it's basically, it's made up of all of your assets, right? So it could be real property, bank accounts, cash, anything that either you and your spouse, or if it's an individual, have accumulated over the course of life, over the course of marriage. And it's basically everything that you are going to account for in your estate plan, and where you would want those assets to go from your estate and to whom. And Bob, I think you were going to say something earlier.
No, that's okay. Go
Oh,
right
okay.
ahead. Thank you, though.
That is what an estate is.
Yeah.
So what happens when you become incapacitated without a plan or an estate plan? So it could be, it's a conservative, if you're alive and not well, then you would be forced into a conservatorship if you don't have any documents and you need someone to take care of you. So that is essentially a living probate. And we have actually had quite a few clients faced with this presently, either for children or for their parents, and they have their parents or their children maybe don't have any type of plan. And so they're being forced into the court system, and the court system is going to dictate the process of this conservatorship or the probate over the individual. And it is a long process, and it cannot be as immediate as people's needs may be.
Yeah, if you think about it from the standpoint, if I am unable to act on my own, if all my assets are titled just in my name and I don't have an estate plan and I'm not able to act on my own, I need somebody to step in that'll have authority over my assets. And if I haven't done any planning, the only way I know to do that is through a conservatorship. You have to go into court and get somebody appointed that could be, the court would give the authority to control my assets for my benefit. And that would be a conservatorship. And again, I mean, that is something, if you do the appropriate planning, what we want to be able to do is avoid that conservatorship process in families that work together and that are able to. Not to saying that conservatorships don't have their place. They do have their place where there's abuse involved, or individuals are there are many circumstances where conservatorships are appropriate, but in most families, avoiding them would be a good thing. Would you agree, Karishma?
I would agree.
Beautiful. Thank you. And that leads us to, well, do we have a do nothing plan? Why, yes, we do. The state of California provides you with an estate plan, or what do we call it in our office?
Well, I think I like to call it Gavin's plan, but or the do nothing plan.
Right.
That's right. That's right. So if something happens to us, and we're incapacitated and we don't have an estate plan, we go through the court system for that living probate. If something happens to us and we pass and we don't have a existing estate plan in place, the state of California, or our lovely governor, Gavin Newsom, has a plan for us. It's the default plan, and we refer it as the laws of intestacy. And that's fine. There's a plan. If I pass away without any documents, without any of my wishes being written down, the state will say, hey, Roxanne's assets are split in a certain way. And that's fine, except for the fact that, one, do I agree with that plan? Are the assets going to go to the folks I want them to be distributed to? And two, there is a complicating factor in that it has to go through the court system. So how does this state of California plan work? Well, it's basically a probate process. So, most of us have probably heard that we want to avoid the probate process as much as possible, right?
Well, now I don't know about that. What about the lawyers?
Oh, well, the lawyers
love it.
The lawyers love it. I'm not going to lie. We love it. I mean, we do spend most of our time trying to help our clients avoid that probate court process. But the reason that we don't look down at probates is that us attorneys our fees are articulated by the laws of California, and it's a statutory fee. The state tells us how much we get paid on those probates, and it's a significant amount. Okay, the bigger the estate that has to be probated, the larger our fees. So we don't mind them. But for folks who are the clients, it can be perceived as a very arduous process. It's long. There's a lot of court hearings involved. There's just a lot of preparation, and you just there's a lot of hurry up and wait. Whereas if you have an estate plan in place that includes potentially a revocable living trust, that can be handled privately, quickly, and done, very simply. Probate is not quite as efficient, would you say, Karishma and Bob?
No, it is definitely not as efficient.
Not quite as efficient. I think, well, yeah, AARP has said in an article from some time ago, but I think they said the average probate fees were between 5 and 7%, or 3 and 7% of the estate, and the average probate was about 15 months. So that's the average. I mean, that would be pretty much breakneck speed.
Average. And I'm pretty sure that those numbers came out pre-COVID, and with the court systems being strained under, reduced resources, it's even longer now. So if we have a do nothing plan and we don't have an estate planning documents in place, and we're relying on the laws of California, it will go through the probate system. The clients are the personal administrators. They have to open a probate, push it through the court system with legal counsel, and it can be a little bit stressful. Okay. All right. Oop, I went backwards.
Yeah.
And now, well, if we don't have a revocable living trust and we don't have we're not relying on the do nothing plan, well, maybe we have a last will and testament. What happens here, Bob?
Well, I think it's pretty well self-described there. If we do nothing, or if we have a will-based estate plan, so we haven't used a revocable living trust, under either of those scenarios, do nothing or a will, we're going to have a probate that the assets that are subject to probate are going to have to be probated. And so what we put there is the will would say, when I die, please open a probate. And the filing fee for probate is, I think, $460 or $430. That's the fee the court gets. And then, of course, we have to prepare all the documents. And so it is an expensive and time-consuming process. And I think that is kind of described in the next slide, if I remember getting close to that one.
Take a look. Here we go. How it works
so,
through probate.
Right. So here it says assets titled in just your name go through probate, and that would be, and if you used a will, the same thing is going to happen. And what we're seeing there is a funnel where the estate goes into the funnel, and then if you want to advance it one there. So we pay taxes, and you got to pay taxes with a revocable living trust. But then what we have is, if you want to hit it one more time, Roxanne, I think it'll bring those fees in. There we go. They're the probate fees. So there's court fees, and we have to hire, there are appraisers that are appointed by the court. There are, of course, the attorneys get fees, the executor or the administrator is to receive fees. And after all the fees are paid and all the taxes are fees, and it goes through the funnel, then at the end there, as you can see, what comes out of the bottom is what goes finally to the beneficiaries after many months and after many fees and costs. So probate, if you is something typically to be avoided. Number one, I think we may have a slide on this, but yeah, we do. So let's leave it at that. Good.
Great. Thank you so much. I think, there we go. All right. So how do we avoid probate?
By setting up a revocable living trust.
What? So simple.
So a revocable living trust in legal terms is going to be a contractual relationship. What you obviously design your revocable living trust. Once you sign it, it becomes effective. And so right below the legal has the simple explanation, that is the trust, what a trust works like a bucket. Or for Roxanne, it's like a basket. For Bob, it's a grocery bag. So a trust in our office has many different analogies.
Beautiful.
And so the purpose of a trust is, what a trust does is it holds your property, which is the corpus. So these are the assets that you are going to put into your trust. You are the trust maker. You fill your bucket or your grocery bag by retitling assets that belong in the trust, such as bank accounts, checking savings, or real property, and investment accounts. The trustee is going to be the bucket watcher, which I believe in this picture is going to be the dog who is protecting the bucket.
He's really cute.
It's a cute puppy.
It will ladle out contents, and then it has pour out contents. So it may distribute over time, and then at the end, when the trust is going to be terminated, all of the assets are going to be distributed pursuant to the terms, and then the trust will be no longer. So it will be dissolved.
Perfect. Okay. That was my attempt to click to the next slide.
I heard that.
Sorry.
Yes. Well, I'm just going to start talking because I think, yeah, that's what I was going to start talking about. Look at that. So this is, again, if you're looking at the three of us, incapacity is obviously something that's more on my mind than it would be on Roxanne's or Karishma's mind. But, as we get older, incapacity is something that none of us want to experience, but some of us are going to. And if we're going to be have incapacity, the great thing about well, let me put it this way, ladies and gentlemen, when does a will speak? Karishma, when does a will speak? What has to happen to me for my will to speak?
You have to die.
Oh my gosh, it doesn't sound like a very good incapacity planning tool.
Nope, there is no incapacity planning.
Right, not through a will. So a trust provides that. You can name trustees, you can leave instructions. A trust, that's what we call it, a living trust. It lives, it's a living, breathing document. And as such, it can work for me during my incapacity. And of course, that's going to take us to successor trustees. So let's go ahead and talk about that quickly.
Perfect. So a successor trustee is here. It's Wonder Woman, because the Wonder Woman could be the successor trustee managing the basket or the bucket of assets, dealing with the beneficiaries and trying to figure out what their needs might be on a quarterly or annual basis. This same person could be the very same person as the agent on the power of attorney, or they could be coordinating with that power of attorney. the successor trustee is certainly coordinating with the individual's tax professional, which is an accountant or an enrolled agent, their financial advisors, insurance agents, dealing with the attorneys. We have a very close relationship with our successor trustees because we represent them in trust administration matters. And the successor trustee may be also working with medical providers and even the agent for the healthcare directive. So as you can see, this wheel is just the center of the wheel is a successor trustee because he or she touches on so many elements of the incapacitated person's life.
And so they kind of protect and oversee for the benefit of the beneficiaries, kind of, huh?
That's right. And a great example of, we have a video of somebody who's doing a great job protecting.
There's been a lot of changes this offseason for your team. How do you feel your chances are in the ALEs?
I mean, I love our chances. You know, it's been
Oh, well, that's just not going to work, I guess. Sometimes the videos work and sometimes.
Oops. So if you couldn't see the video, it was essentially a video of Evan Longoria being interviewed, and the interviewee is just so, focused on the interview, and she didn't realize, neither one of them at first saw that there was a ball coming at them, and it was headed towards the interviewer's head, and the baseball player turned around and just went boop and caught it. So that's what the successor trustee is doing. They're in the position to protect the beneficiaries and to work with all of the different professionals that are involved. So their job is very much a protective role.
Yeah.
Okay.
So if the trust is the centerpiece of an estate plan, and you have that trustee, and we can take care of incapacity and pass assets to the beneficiary at death without probate, we do need some other documents to have a comprehensive estate plan. And of course, one of those is an advanced healthcare directive or a healthcare power of attorney. In California now, we call them advanced healthcare directives. Some of you, if you're older or you have specific reasons, you may have a PULSE, a physician's order for life-sustaining treatment. They are becoming more popular, but they're typically used for more special circumstances, although they're becoming more mainstream as time goes on.
Bob, who needs like these advanced healthcare directives?
Well, I think that photograph does a pretty good job, or that slide does a pretty good job of describing it. We like to say from 18 to 80 and beyond, and actually 18 because that's when you become an adult and you can have your own healthcare directive. 80 is not a cutoff. It can be, once you're over 18, you should have a healthcare directive because you're going to empower people to make healthcare decisions for you. But I may be getting ahead, so I'll slow down. Go ahead. Yeah. So a healthcare directive, and I'm just going to talk about these and we can advance through the slide. The healthcare directive does essentially three things. It's like a can of 3-in-1 oil, or the Swiss Army knife that we have there. It provides you appoint agents to make the healthcare decisions if you can't make healthcare decisions. That's number one. That's important. And number two, you can make end of life decisions. So you can say how you want your end of life treatment to go. If physicians determine you're at end of life, you can elect to have palliative care. You can elect to have full-on care, and you can leave additional instructions in your healthcare directive. Very important. Those are really the two main components of the healthcare directive.
Yes. And oops, sorry, let me go back.
Yeah, and the slide we'll go back to shows that you can also use the healthcare directive for, we can leave it there, but for donations of organ and tissue is another part that you can use. There's several places in California where you can make those donations known, and one of those is your advanced healthcare directive. Yeah.
It's actually better we didn't see that slide because it was just a bunch of surgeons surrounding an operating table, and I was looking at it and it looks kind of vulture-y. So, it's only if you want to donate your organs will they actually be taken. Don't worry. The surgeons are not just standing there waiting.
Yeah.
And
How about the power of attorney for finances? That would be another document that goes with that centerpiece living trust, huh?
yes, it does. The power of attorney for finances is a document that becomes effective when you are incapacitated, and it controls your property and assets that are outside of your trust. So this would be things along the nature of retirement plans, life insurance, handling things maybe at the DMV, changing your address. So things that for managing assets that were not transferred into the trust if and when you created a revocable living trust.
Beautiful. Thank you. And if you have a revocable living trust, you will also want to have a pour over will. Now, earlier, Bob had talked about the last will and testament, and yeah, it's a one-way train ticket to the probate court train station. Why would I want to use that? Well, sometimes we create that bucket or that basket, and we put all our stuff in there, but later in life, we acquire additional assets that we forget to put into that trust basket. If that scenario is with me and I've put all my stuff in the basket, 5 years later, I buy a vacation home, I forget to put that vacation home into the bucket and I pass away, well, it's floating outside of trust. It's floating out there and it's probatable. So we have a pour over will that captures the asset in case it's left out there. It does have to go through probate court, but it's a truncated process. It's not the full blown scary, probate process. And the will enables our executor or personal representative and trustee to grab that outside asset and pull it into the trust so that then it can flow through the centerpiece of our estate plan. So this is a pour over will that works together with your revocable living trust to reduce the burden of probate court as much as possible.
Perfect.
All right.
Wow. Guess what? We're out of time. There you go. There's a basic comprehensive estate plan outline for you, the documents that we covered. Those are really the essential. There's a lot of other, we're doing an estate plan. We use many other documents, but this is a good starting point of a comprehensive estate plan. Would you agree, Karishma and Roxanne?
I would agree, yeah.
Yeah.
Absolutely.
Okay.
All right. We'll turn it back over to Morgan.
Morgan.
Yes, thank you. Just as a gentle reminder to our attendees, if you're not on our newsletter, here's the information to contact me and I can go ahead and get you registered, or you can register on our website at the very bottom of the page. Also, McDowall Cotter is on all social media forums, including TikTok as of last week. So please go ahead and follow McDowall Cotter for all updates on our firm and vlogs, etc. You can find all that information on our social media as well. And I'm looking at our chat and Q&A, and we have no questions as of right now.
We answered
a
everything.
great job.
Wow. Well, thank you, everybody. We really appreciate your attendance. We enjoy doing these and we love having people listen in. And so thank you and have a great rest of the day.
Thank you, everyone.
Thank you, everyone.
Thank you, Roxanne. Thank you.